I haven't heard from Claire Curran. I hear from Claire.
Thank you, Mr. Chair. I'd like to address my remarks on this mammoth piece of legislation to clauses 167, 401 just briefly in parts 1 and 2, and then concentrate on part 5. I'm hoping I can make an additional contribution on this issue because and this is the clauses which remove the final written removes the requirement for the final written judgments to be published on the internet. And as you've heard, and I'm not going to go over this again, but as you've heard, it came back from the Select Committee with those clauses removed. So those clauses were originally in the bill. My colleague Jacinda Ardern has put up an SOP on section 401, not to reintroduce them, but to put in a time period, some time out in 2018, to allow there to be preparation for the publishing of these judgments on the internet. But I would like to, and of course we support that SOP, but I would like to remind the government of two things. One is its own KPIs, shall we say. It's the Better Public Service KPIs, result number 9, which is that New Zealand businesses have a one-stop online shop for all government advice and support that they need to run and grow their business. And the next is result number 10, New Zealanders can complete their transactions in government easily in a digital environment. Alongside with that, and we've had several references today to the Open Government Partnership, is a requirement as part of the Open Government Partnership that we're signed up to as one of 69 countries for easy digital interaction with government for citizens. Now, surely this is part of that, and taking away that requirement ultimately seems to be driven by financial considerations. So my question to the Minister and the Chair on this is, was the ruler put through it by the Minister of Finance and said, no, sorry, it's going to cost too much? Because we can see by the advice that was given by officials that there's 15,300 final decisions that fall within the scope of that bill. So was the ruler put through it by the Minister of Finance, and was the ministry told that yes, do it on a voluntary basis, but only within the resource cap envelope that you've got, and that you can't have any extra money? Because that's, it seems to me, as to why they have actually removed that provision. So I would like to then turn my attention to part 5, which is is a substantial part of the bill and a part that we support, which sets out the methods to enable and govern the use of electronic technology in court and tribunal proceedings, including allowing all current paper-based requirements to be replaced with electronic processes. Now, this is not like the previous part. It's not uploading judgments, it's processes, it's electronic processes. And while we support this and think this is a logical and necessary step to take, we do want to raise a few concerns. And we note that back in 2012, when the Auckland registry went electronic, that there were serious delays and huge backlogs within the family court, with the Law Society warning that it was only a matter of time before someone was seriously hurt or worse. The Ministry, in fact, the Justice Secretary, Andrew Bridgman, I'm not sure if he's still the Justice Secretary, but this is back in 2012. Yes, he is. He apologised to Parliament, and good on him for doing that, admitting that staff weren't fully prepared for the change and that the Ministry did not engage enough with the legal profession early or active enough. So I'm just introducing a note of caution around that. I imagine that was discussed at the Select Committee, and that how important that is. Can I, in my final seconds, just say that this bill doesn't go far enough, that there's a next part to this discussion around the move to electronic processing, and that is to move to an online court system, which shouldn't be years away. It should be something that we're preparing for, thinking about now. Former District Court Judge David Harvey has done a lot of work on this. I know the Minister has expressed some comments This is happening now in the UK. It's about access to the court system, particularly from people from lower incomes, and it's something that we heartily support.
Jamie Lee Ross.